Well, I guess the hot topic lately, and I'm great with it, is discussing common law. And of course, there's so many different ideas of what common law is, thereby creates the relative distortion that we have when we are facing the government and the courts and such. And while I was commenting on one video, which I just uploaded in my response to concerning common law courts and such, and by the observation deck, I believe it was the host show. There was a one that caught my eye because it was again discussing common law, and I was looking forward to listening to what they had to say. And it's by a gentleman whose name is Richard Vobes. I guess he runs a show, or he does run a show, a successful show at that, in discussing matters that we find dear to our heart, and especially now with the system being as crazy as it is. And he brought a presenter on his show by the name of Ruth Skolmli, who also has her own website and talks to sovereignty of law. And she, I guess, had been involved in academia and through the programming process of learning in law school what she thought was law, and through her own discoveries, realized, you know what, that's not what law is. It's not as complicated as it appears to be, where we have to go through millions of statutes, acts, codes, bylaws, and such in order to even determine what it is. It's quite simple. Yet, she fails to hit the mark, if you will. And again, lulls us into that sense of security that, you know what, law is just about really doing no harm to another. And then she branches on from that and discusses a very generic term of unalienable rights, and that we've got to find where those are, which are entrenched in natural law. But when we interact with society, then of course we're faced with commanding what is right. Well, I'm actually going to quote Blackstone's commentaries here, that we're commanding what is right, and prohibiting what is wrong. Well, what is law, though, and how do we get involved in these societal agreements, which, of course, I bring to the table and discuss through my English law series? If you don't get the grounding of what that is, then even when you say a simple broad stroke view that it's harm no other, that still doesn't develop law to really get to the foundational principles of how it is that you could even harm anyone. For instance, right now the system has to move, as we have learned through my series, that we're moving from a trust for sale scheme that began in 1925, and it's coming to an end. So the government is essentially fulfilling that agreement. It has an agreement to run the program of its lease for 99 years, and it's at that 99 years it's got to then move on to a new agreement, which is the fourth industrial revolution, in the public is recognized as, but essentially it's the fourth level of use to land. Now, for those who are just coming on broad hearing me for the first time, all English law is about rights to an estate interest in land. It's not about controlling people directly. It's not rules over people, because again, as Ruth had also alluded to, that we have unalienable rights. So if we have unalienable rights, then how can we then be measured by some sort of evolution of law that then forces their will upon us when we don't want to interact? Well, it's not enforcing, law is not about enforcing rules over us as individuals. And that's a very key point, individuals. Because an individual, you have unalienable rights. But as soon as you join in a group, The rights of the group then overreach your unalienable rights, and that group is a fiction created by law because it's a mindset. It's not your set in itself. It's not your being. It's not your living essence. It's as soon as you create an agreement, that becomes a fiction in law that needs to be dealt with. Now that's what law deals with. It deals first with land and your rights to that land interest, to then creates an obligation for you to perform because you are doing something within English law to affect that agreement to that land interest. Thereby now creates rules over you, which is overreaches your free will. So when we just say not creating any harm, that is, that's not very, that's like a descriptive view. It's not explanatory, and you're still going to get yourself in harm. For instance, you own a piece of property, okay, and you want to lease out that piece of property. Now it's a mother and let's say, and a couple of kids, and the mother comes on hard times and she's unable to pay the rent. That through the agreement is made to you in order for that person to hold that interest in that property that you own. Okay. Now, when she's unable to pay the rent, what are you going to do? Okay. Is that a harm to you? Well, you're not physically harmed. So no, you're not harmed at all. So then, how does common law come into the situation? It doesn't necessarily, because common law deals with a separate subject matter than it does with what we are learning what law is, in as much as that we're dealing with an equitable interest that we made a purchase and we own that right to that equitable interest, to which now we're leasing out. I hope I didn't convolute that, but I'm also speaking to the people in my audience that have come to know what I'm speaking about through the law series. But you're owning a right to hold that land interest as an equitable interest, and now you're leasing out that piece of land to another party. It has nothing to do with physical harm in this matter, because we're not dealing with common law, we're dealing with equity. So now let's further develop that. So now you're going to because that mother and her children is unable to fulfill that agreement, now are you going to serve an eviction notice? And if you're serving an eviction notice, are you not harming her physically? So how do you get around that? You see what the problem is? Or let's just revert it. Let's say I'm a slumlord, and and she's got some repairs that need to be done. The heat's not working, or the hot water tank's not working. What is her recourse? There it is. The agreement is the recourse. It's not, we're unable to not cause harm to another and make an agreement valuable at the same time, or because each time that we think about the human prospect of things, whereby the suffering that will occur on either side, we'll never be able to make any valid agreement because of having those unalienable rights and free will, and also not causing harm to the body of somebody. So what has happened, what law does, is it only looks to the agreement, and then the agreement becomes the value, which overreaches those natural rights that each of us have, so that we can, it's indirectly cause harm, only because we will cause harm to ourselves through the commercial aspect of that agreement, which is an equitable interest to land. Okay, so now let's just move into that. Then law becomes subject matter. And see, that's what really separates our absolute rights from the relative rights. Our relative rights is those agreements that we make that we need to be honorable in. It has nothing to do with the common law and our natural rights. It's a deal with the equitable rights that we are agreeing to. So the court only looks at that agreement. And for instance, too, we can look at, and everybody's going into the aspect of, a council tax. And I'm only speaking because I speak to a lot of people in England and so forth, and that seems to be a hot topic. And, what gives you a right to enforce this council tax or cut off my heat or do anything? Well, the agreement does. Okay? The agreement does, just the same as the landlord-tenant agreement. The agreement does give them right. And if you are part of a society, a municipality, each one has a obligation within that municipality that they should all be sharing equally. And if you have property within that municipality and you've purchased it, then you've agreed to that those statutes and acts and bylaws and so forth that everybody else is equally have accepted. So, for instance, if you find out next door your neighbor doesn't have to pay council tax, well, and everyone else down the street do, well, doesn't that create an issue? So what it does is make a broad stroke that everybody has to pay council tax, and if you don't, well, then this is what happens when you're not paying. So it's not against you, and it's not, we have to understand subject matter creates jurisdiction. That is it. And your status relative to that jurisdiction or that subject matter then creates the constantial agreement that is formed so that everybody's treated equally and equitably within that system, which is essentially you have made an agreement based on the fact that you are doing something within the system, such as purchasing property under government. Why are you purchasing property? That's a good question. Why are you purchasing property under government? And if you don't know that answer, well, then maybe that's a place that you should start. Again, people that are listening so far in my English law series, they're realizing the answer to that question. Government is a leaseholder, just like the tenant-landlord agreement. Government doesn't own land. It's leasing the land and administrating over that use of land. Okay, it's the second level of use to land, to which the first level is in the common law interest, and those are those strict settlements in land that are now held in trust, to which then the government essentially contracts through to use the land that then allows its citizen base, which are just worker bees, the enfranchisements, who then become quasi-trustees to take care of that land while it's in use. But who are the true owners? You are. Okay, that was settled back in 1688. The land moved back into the interest of the people. And then the Act of Settlement, 1700, what did it do? It established that the birthright of the people is that English law. So you have to come understand that we're not, if you don't you don't come to the comprehension that we're dealing with a land interest only, and then you're making some sort of agreement somewhere along that land interest. That agreement then is relegated to its subject matter. It has to be to that subject matter. If you have an equitable interest to that subject matter, currently on a trust for sale scheme that started in 1925, then that's the subject matter, and you have certain statuses within that subject matter. And yeah, you can be called people, but that's not really the people. You are actually acting as that citizen agreement overreaches the concept of people. People are before government. In fact, even before monarchy, because those are titles and those are fictions of law. Titles are fictions of law, and you have more power than the fictions of law, but you're never there because you're dealing with an interest under government who has a second level use to land, which before government is held the land and is settled the land in the monarchy, who holds that interest as in which, as you may have heard somewhere along the line, and you don't maybe have an understanding what it means, but can do no wrong. Why cannot the monarchy? Why isn't the monarchy unable to do no wrong? Well, essentially, all the monarchy is doing is holding the settled common law for your benefit, which is that strict settlement of land, which creates the value for which then the government comes in under a trust. The trust separates that common law interest to create an equitable value to which then the government can use and then administrate over, and then has to pay for the right to use, just like a leasehold agreement, a right to use that land and use the citizen base to come in under, who are the worker bees, to take care of that land and use it in the interest of what government's grant has been given. Okay? So I just wanted to clear this up. I mean, someone who's been in law school, I get it. They don't understand law. And you know what? I mean, there's going to be a very few that would understand what law is, and because they keep on taking it still, they're filtering it through the fictional concept of what government has given them to be educated through to understand what law is, and they're just, doing a broad stroke, create no harm. Well, you are unable to not create harm in a system because the entire system is not dealt with your individual unalienable rights, and the sentient being, the live being, it doesn't deal with it. It deals with the agreements. And those agreements will inadvertently create harm. For instance, you're creating harm every day. It's exactly the same as the game of Monopoly. I've spoke about this already, that the entire concept of the game of Monopoly is to bankrupt your neighbor. Well, that's what you're doing in the system in order to facilitate your rights to hold property under the system. You have to bankrupt your neighbor. Someone has to lose. That's how the money system works. You have to create cancer in order and create disease and create waste and create disturbances and issues upon the land in order to continue this system that you are continuing to be in agreement with. Okay? All those things are part of the process of the government, what the government controls. The government doesn't deal with the principle, as again I've spoken about. The principle is before the government. That is life, and government can't patent life, so therefore it creates patents for things that it creates and establishes through its own creation, so that it can patent, and those things are actually counterproductive to life because, again, government doesn't deal with life. It deals with agreements to the use of land, and it patents its rights, because that's where the value is, to then continue to allow citizenry to produce things that then in its own demise destroys itself because it's counterproductive to life. And that, I can keep on going, but I've gone into my own little 17-minute soapbox presentation, and I'm going to end it here. But if we go through the English law series, and when we're dealing effectively with English law it's lands, it's rights to estates inland. That's what it deals with, to which then it looks to see where you are obligated to provide a performance based on that agreement. It has nothing to do with your rights are unalienable rights. It because you are overreaching it through the agreement, and that is only makes that agreement valuable is if it can overreach your unalienable rights. With that, have yourself a great day, and let's carry on and get down to the bottom of this and return to our true power by understanding what is law.